Hello friends, in the series on the income tax cases, today we will discuss a very important issue which is based on interest on income tax refunds under section 244A. As all we know that the revenue has introduced a Direct Tax Vivad scheme 2020, and according to section 7 of that Vishwas scheme 2020, there was no interest payable to the assessee prior to the amount paid by the assessee before the declaration. But at the same time, the revenue was bound to issue the form 5 within 30 days and determine what is the amount payable by the assessee or what is the amount due to the assessee. And if the revenue does not give refund to the assessee within 30 days from that form 5, so whether the assessee is entitled to interest under section 244A, this issue has been taken up by Honorable Kerala High Court in the case of Satwashil Vasant versus Assistant Commissioner of Income Tax and another. This case is reported in 479 ITR at page number 493, and the date of the judgment is 7th January 2025. The facts of the case are very interesting. In the present case, the assessee was a non-filer of income tax return. The assessee was not filing the income tax returns. Some cash and gold was seized, and after that, when this cash and gold was seized, there was requisition by the income tax department under section 132A, and accordingly, on the basis of that cash and gold seized, the assessment of the assessee was completed for the assessment year 16-17, and some additions were also made and penalty was imposed under section 271AA(b). After that, the assessee opted for Direct Tax Vivad scheme 2020, and form 5 was issued. When this form 5 was issued, the revenue adjusted the cash and gold seized and some amount was refundable to the assessee. But when this form 5 was issued, after issuing form 5 up to 23 months, the refund was not paid to the assessee. After that, the refund was paid. Now the assessee was contesting that the interest on the refund amount should be paid for 23 months which have been delayed by the revenue after issuing the form 5. So the question before the Honorable Kerala High Court through a writ petition by the assessee was that whether this interest is payable to the assessee under section 244A, especially when there is section 7 which talks about non-payment of the interest to the assessee on any taxes paid before the declaration made by the assessee. When this petition was heard by the Honorable Court, the court was of the opinion that the section 7 prohibits only the payment of the interest on the taxes paid by the assessee before the declaration is made by the assessee to the department. But once the form 5 was issued, the refund should be given within 30 days, and if that amount is not paid within 30 days, then after that, for whatever period the refund has been delayed by the income tax department, the assessee is well entitled to get the interest at the rate of 6% according to section 244A. The revenue was pleading before the court that in the present case the assessee is a non-filer, the assessee is not cooperating with the department, the assessee has filed the return only when there was some seizure. So for this, the court said that these things does not matter. Once the assessee has filed for the scheme and he was eligible for the scheme, and once he was eligible for the refund, then it was a matter of accountability of the department to give the assessee the refund within time. The court said that if the refund is not given within 30 days, then it is a gross default on the part of the department, and the assessee is well entitled to the interest under section 244A at the rate of 6%. At the end of this video, once again I am repeating the name of the case. The name of the case is Satwashil Vasant versus Assistant Commissioner of Income Tax and another, and this case is reported in 479 ITR at page number 493, and the date of the judgment is 7th January 2025. Thank you, friends.